record in People versus William Isaacson. This is file number 255084. The record should reflect Mr. Isaacson is present here in the courtroom today. Mr. Haney, are you able to hear me okay?
I can hear you fine, Your Honor. Thank you.
And we have Mr. Ziegler present in the courtroom. We're set for a final status conference in this case today. We have trial set to begin on March 17th. Mr. Haney, I know you filed a motion for to adjourn the trial in this case. So can you just state for the record your reasons for wanting the adjournment? I know you filed the motion, but I'd like you to state that for the record as well, please.
Certainly, Your Honor. Thank you. I did meet and confer with the prosecutor. I understand his position and the reasons for his position in not concurring with the relief sought by way of the motion. I will note we had a very difficult time, Your Honor. I think I addressed this in the prior hearing, getting the body cams and the dash cams from the people. No fault of their own. I don't know what the issue was with the discovery that they provided. We, at the end of the day, had to go directly to the state police. That was a recommendation of the prosecutor. I believe on October 16th, it was recommended that we seek the discovery directly from the state police. We did. We FOIA'd that information on the 21st of October. State police responded that it would take 63 days for them to produce what we sought. It turned out that what we did seek was rather significant. It was, I believe, 10 to 12 body cams and dash cams that were several hours long. We finally did obtain the body and dash cams probably in the second week, if I recall, in February. I believe I noted it in my motion, and at that point began discovery review. We did also receive on the 6th of February 4 additional discovery links from the people, which then puts us up pretty close to within a month almost of the trial date. In reviewing the body and dash cams, it struck me that there may be a need for an expert in this case, Your Honor. And until I had an opportunity to review that material, wasn't really clear to me how that could be potentially exculpatory to the defense. So, we're not trying to delay this. I understand that there are victims involved that want their day in court. I understand that my client wants his day in court as well. So certainly this is not a tactical delay, Your Honor. I just want to make sure Mr. Isaacson receives a fair trial and is able to defend himself and present his defense in the best manner possible. Thank you, Your Honor.
Mr. Ziegler?
Your Honor, we would oppose the delay for the reasons we put in our response. I think the two primary reasons would be, number one, while it is a lot of video, the defense by their own motion got it about 4 weeks ago. They'll have another 2 weeks before trial. To me, that's more than sufficient time to be prepared. The facts of this case are not incredibly complicated. It's obviously a very serious matter. That's a very weighty matter. But at the end of the day, it is a drunk driving trial. So it's not like, and we did hold a preliminary exam in this matter as well, Your Honor. So several of the witnesses have already given their testimony. I don't expect their testimony to change. The second reason, I think more important reason, is we have a number of people, I would guess dozens of people coming here from Canada, members of the victim's family, coming to watch the proceedings. They've made travel arrangements. They've had to take time off work, arrange for pet sitting, had to book hotels to be here. We were told months ago that this was going to be the trial date. We haven't heard anything from the defense until a couple of weeks ago that there were issues with them getting the discovery. They have known since, I think, November. It said in their brief that MSP was going to be delayed in getting them this material. They could have filed that motion back then. They did not. This is the first time I'm hearing about the potential for some expert testimony. I'm sure Mr. Haney and I will discuss that further. But I don't know what that might be at this time. So I'm just asking, Your Honor, the victims have a right to a speedy trial in this case, just as much as the defendant does. The people have a right to a speedy trial as well. It will be, if this case is moved, most likely it will be past the year mark since the victim in this case died. I know the victim's family is desperately seeking closure in this matter. And so I would ask the court to keep the trial date scheduled.
So Mr. Ziegler, I mean, I don't have a transcript of the prelim. All I have is the information in the file with the allegations. So, I mean, can you tell me the factual allegations of what took place here, so that I could better understand what the defense is saying with regard to their need for a video?
The allegations are that Mr. Isaacson and 4 other people, there was a party. I believe all of them were intoxicated. They went out on an ORV. Mr. Isaacson was allegedly the driver. He's likely going to dispute that at trial, say that someone else was driving. There were 5 people in the ORV. The ORV rolled at some point. 2 persons were seriously injured in that accident, and 1 person was killed in that accident.
Okay. So Mr. Haney, I mean, can you tell me, give me the reasons why you think you might need an expert in this case? I mean, what
Yes,
is an expert?
Yes, Your Honor. First of all, the evidence at preliminary examination, I don't think it was explored very thoroughly, just reviewing the transcript. There was damage to the windshield. First of all, the individual that was alleged to be the passenger in the ORV, he ran. Okay, it's our position that he ran because he was the driver of the ORV. He ran and he fled and he hid until the next day. There was substantial damage to the windshield of the ORV, where clearly somebody's head hit the front of the windshield. My client's position is he was the passenger in that ORV, and that the other gentleman who claimed to be the passenger was actually the driver and fled. There was really not a lot explored at the preliminary examination relative to the damage to the front windshield and how that was consistent with the injuries to my client's face. My client had facial injuries that would be consistent with damage to the right side windshield or the passenger side of the front windshield. The individual who ran, who allegedly was the passenger, who we believe was the driver, he had absolutely no facial injuries, and the driver's side of the ORV, the front windshield, had absolutely no damage to the front windshield. So in viewing the injuries to the 2 individuals, that one of them was driving, I did not have that evidence until I saw the body cameras and saw the significant difference between my client's face that was completely damaged to the right side, with obviously hitting the windshield of the glass, relative to the other individual who ran through the field that night and hid, who had absolutely no facial injuries. So it strikes me that it could be exculpatory, it could be beneficial to the defense that an expert could provide testimony relative to those facts that were not even really, to my understanding, reading the preliminary examination, they were not addressed at all at the preliminary examination. Not to mention the front windshield that clearly somebody, for lack of a better word, face planted on the right side in front of the passenger windshield. There was absolutely no forensic examination of that windshield with respect to any DNA, to respect to any hair samples, blood, nothing that could have determined who was driving and who was the passenger of that vehicle. This whole case comes down to the fact of who was driving that vehicle that night, my client or the guy that ran through the field. And that is, we had three drunk people in the back seat. One, unfortunately, tragically passed away. The other 2 not only had head injuries, but were severely intoxicated. And their identification is what I submit is what the prosecution is going to rely on to convict my client. And what I would contest is not a drunk driving case. Drunk driving cases don't carry prison sanctions. A conviction in this case will result in Mr. Isaacson going to prison for a long time. So that's my understanding, Your Honor. That's my representation why I believe an expert would be significant in this case.
Well, what I'm trying to determine is what did you learn from the video that you wouldn't have already known that would now spur you on to needing an expert? That's what I'm trying to determine, because to me, the request to adjourn this turns on, the disclosure of that evidence and whether you've had enough time to fairly go through that evidence and be prepared for trial. So I'm trying to determine to what extent there's been some type of prejudice to your client in terms of preparation. So what's different now than the information you had prior, and why now does this create a need for an expert where prior you couldn't have known of the need for an expert.
Yes, Your Honor. The body cam photos, or sorry, the body cam footage depicted the physical injury to the two gentlemen that were seated in the front of the ORV. There were no photos provided by the state that provided any. I don't know why the officers didn't take photographs, but I didn't have any photographs that depicted the degree of injury on either my client or the gentleman who ran through the field. That's the difference. I didn't have that evidence. I didn't have that ability. I had no direct evidence, no photos of the facial injury to my client versus the lack of injury at all to the gentleman who ran through the field. And Your Honor, I did.
Well, let me just stop there. Let me, because I have a question, and I have to ask my questions when they pop into my head, Mr. Haney. Yeah, otherwise sure. I lose. So, no, I mean, you knew about your client's injuries, though, I'm assuming, and I'm assuming there's information out there about the lack of injury. So is the only difference that you didn't have video of, video depictions or, physical depictions of those videos as opposed to descriptions in police reports or hospital records? Is that what you're saying the difference is?
Well, I'd also say the difference was that in the police report, it didn't adequately describe my client's injuries. It said my client had a laceration singular to his face. When I submit the photographs that I was able to extrapolate from the body camera show multiple lacerations and bruising to my client to the right side of his face that are consistent with what would be a passenger of that ORV hitting the front of the ORV's windshield. The images that I was able to extrapolate from the body cameras of the individual who ran, who allegedly was the passenger of the ORV, for the jury, I think it demonstrates what could be very significant evidence, Your Honor, to actually see the photographs and see the difference between the two men that were sitting in the front seat of that ORV, where the driver's side ORV windshield is virtually pristine. The passenger side ORV of that windshield is obviously face planted. Somebody struck it with their head. And to see the images of the two men, I think would be extremely important for the defense to present at trial. I didn't have that ability to take a still from a body cam interview. For instance, when they interviewed the man who ran from the ORV, they didn't find him until the following morning. I'm taking images or photographs of this man who ran from the ORV and able to capture photographs of his face that I would present to the jury. I didn't have this information until recently. And Your Honor, I had to go through 13 to 14 hours of both dash and body cam footage to even be able to get to a point where I was able to extrapolate and create these proposed exhibits that I think the jury would never be able to fully understand or appreciate merely by what may be misrepresented in either a police report or be misremembered or misrepresented by a police officer testifying a year after the fact, trying to explain the extent of the injuries of these two men. I believe this is the evidence that could very well acquit my client, frankly. This evidence of the injuries, the facial injuries, and the compared with the damage to the windshield of the ORV, Your Honor.
All right, Mr. Ziegler, anything further based on those arguments?
Your Honor, just that I recall from the preliminary exam that this was discussed with one of the troopers. It was a different attorney at the time of the preliminary exam. So I'm not saying Mr. Haney is trying to misrepresent anything. But I recall the preliminary exam, Mr. Fragel asked one of the troopers several questions along these lines of where the damage to the windshield was, whether there was any hair or blood in the cracks in the windshield, whether any forensic examination or stuff to that effect was done. All these questions were asked at the preliminary exam. And so to say today that these issues weren't known to the defense, although granted it was a different attorney, he had to get the video, he had to get the transcript. I appreciate all of that. But these things were known at the time of the preliminary exam, Your Honor. So I don't think they constitute good cause for an adjournment today.
All right. Mr. Haney, just remain on the line. Mr. Isaacson, you can have a seat there for a second. I'm just gonna take a short break. I need to take a look at one issue. It won't take long, 5 minutes or less, and I'll be back on the record.
Thank you, Your Honor.
Podium there. We're back on the record in People versus Isaacson. So thanks, counsel, for your patience there. I just had to check something in the file. So I've listened to the arguments of counsel here on the record today. I did review the motions and the law applying to adjournments or continuances prior to the hearing today. First of all, whether or not to grant an adjournment is a matter that's within the discretion of the trial court. The court is acting within its discretion in ruling on that motion here today. The court can grant motions for adjournment of trials in criminal cases only when there's good cause shown. The party requesting the adjournment has the burden of establishing good cause for an adjournment. There are a number of factors through case law that the court has to consider, particularly in criminal cases as opposed to civil cases. And looking at those factors, in my view, there's only one really that's, or perhaps two that are really applicable to this case. One of those factors is whether the defendant is asking for an adjournment to assert a constitutional right. Typically that arises in the context of requests for new counsel. That's not what we're dealing with here today. You know, this is a first request for an adjournment. One of the factors the court is to look at is how many adjournments there have been previously. This is a first request for an adjournment. So that's not a factor that works against the defendant in this case. The other factors are whether there would be prejudice to the defendant in not granting an adjournment, and whether the reasons for the request have resulted from some type of lack of due diligence or negligence on the part of the defendant in preparing their case. And those are the two that I think are the most applicable here, and they kind of go hand in hand. So, you know, first of all, I think with regard to the timing of the motion, it appears that the defendant got the discovery on or about February 5th. The motion was filed on February 9th. I mean, it's being heard today, but I don't view it as a motion that was brought on the eve of trial. So it's not something that was brought, I think, late. I think Mr. Haney was diligent and soon after receiving that discovery and filing the motion. So I don't view this as a late motion or a motion that's being brought on the eve of trial, which is something that would be significant in terms of determining whether the defendant hasn't exercised due diligence. However, that being said, certainly, you know, the information itself, I think the defendant has had since February 5th, even if it's voluminous amounts of data and video. I think the amount of time from February 5th to the time of trial is sufficient. Can you leave that door closed, Deputy? Thanks. Is this, if people need to come in, just have them wait a minute. Okay. It's very loud out there. Lost my train of thought. So there's been a sufficient period of time in which the defense has had to digest this new evidence and to be able to use it to prepare for trial. So I don't think the disclosure of the evidence in and of itself or the timing of that is a reason to adjourn the trial. I think the best argument put forward by the defendant here is the need to retain an expert. And when I look at that and the reasons stated by defense counsel, and that, in my view, is essentially that, you know, now they have video evidence of things that maybe they had descriptions of or statements about prior, and that video evidence supplements and adds to it and provides a different view and perhaps a contrary view of some of the information that was known before the video. And that difference is what drives the need for an expert. In this case, I find that is not a sufficient basis to request an expert at this point in the case. while that information may be something that the defense hasn't seen until February 5th, certainly the information itself is not new. The defense, it doesn't sound like the defense, which is that Mr. Isaacson was not the driver, is certainly not something that's new. So in my view, the video evidence certainly supplements that, but the defense certainly had their client at their disposal to talk about his injuries and all the records relating to his injuries. And so if his injuries are something that would support the need for an expert to testify about where he was in that vehicle based on those injuries, that's something that they certainly have known about for a long time and could have retained an expert to render an opinion based on his own description of his injuries, his hospital records, and so forth regarding his injuries. And if this were a case where they had an expert and that expert had rendered opinion, and now the expert had viewed the video and said, wow, I really need to review my findings and I need more time to look at this video and render a different opinion based on this evidence, then I think defense would have a better argument to adjourn the trial in this case. But to not have retained an expert at all, I don't find that this video is so new or so different in terms from an evidentiary standpoint that it's giving rise to the need of an expert where there wasn't any thought of an expert being needed before. I think if they need an expert now, they would have needed an expert before, regardless of this new information. So I don't find that that would be a reason to grant a continuance in this case. It's something that the defense could have or should have known about before. And this new evidence doesn't create a new need for an expert at this time. So for those reasons, the court is going to deny the motion to adjourn, and the court will proceed as scheduled on March 17th. Given the nature of the motion, given that it was filed, on February 9th, and that the defense has been waiting for a ruling on the motion, I am going to allow an additional period of time for the parties to negotiate further in terms of a plea cutoff, which was part of the hearing for today. So to the extent that there are any further plea negotiations, the court will grant the request to adjourn the plea cutoff for 7 days from today's date. So the parties will have that period of time. If the court doesn't receive notice that an agreement's been reached within 7 days from today, then we'll proceed, and that will be the plea cutoff, and we'll proceed with trial on the 17th. Because this is your motion, Mr. Haney, I would just request that you prepare an order reflecting the ruling of the court today for the reasons stated on the record, and either submit that under the 7-day rule or with a stipulation as to form from Mr. Ziegler. Mr. Haney, anything else that we need to address for the record here today?
No, Your Honor, I would just inquire. I don't believe we had a trial order with respect to exchanging exhibits. Is there procedurally a period of time that the court would require or request the parties exchange exhibits prior to trial?
Usually I send out a scheduling conference order. I'm just looking in the file, maybe because of the change in counsel that didn't occur in this case. That's entirely possible. So Mr. Haney, I will get that to, I'll get that scheduling conference order to you that reflects those timeframes. We're still well within that period of time. I will state that Mr. Ziegler, I usually request the prosecution to submit in Word format their proposed jury instructions and exchange them with defense counsel. The pretrial order is going to say, Mr. Haney, that for you to do the same. Typically, though, I just ask defense to submit in Word format any different instructions or additional instructions or objections that they have to the prosecutor's instructions, as opposed to submitting a full, set of instructions. I don't need to do that from you, Mr. Haney.
Yes,
I just really need to know which ones you're disagreeing with or which ones you would like in addition.
That's fine. Thank you.
Okay, Mr. Ziegler, anything else from your side?
No, Your Honor.
Okay. All right, thank you. That's all for this hearing today. Mr. Haney, the only other thing I would say is, you know, typically, I don't know if you had any other questions about how, just nuts and bolts, how we run trials in this case. Typically, I ask counsel and their client to be ready to go at 8:30 in the morning of trial. We begin with jury selection. I do some basic voir dire myself, but I do allow counsel to do some voir dire of the jury. I don't think you've tried a case in my court yet, but Mr. Ziegler, I'm sure, can represent to you that I view the purposes of voir dire very strictly in terms of the court rules. So I view them as, you know, whatever voir dire is necessary to discover challenges for cause and for counsel to reasonably be able to exercise their peremptory challenges. I do not allow attorneys to try their case in voir dire, and I have and will continue to stop attorneys when I feel like they've gone too far into arguing their case. So I do view voir dire as being strictly for the purposes allowed under the court rule. And then once we have a jury selected, we typically go right into, you know, opening statements. So we don't do jury selection on one day and then come back, you know, to begin the trial the next day. We just go right from jury selection into the trial. To the extent that you need to use, we do have a large screen in the courtroom that counsel can use for playing videos and for demonstrative exhibits and so forth. To the extent that you want to use that or any other technology, our courtroom is small. You know, the well area of the courtroom is small, and our technology, you know, is limited. So to the extent that you do want to use that, I would encourage you to contact the clerk's office. You're free. We would make the courtroom available to you if necessary so that you can see it, see what technology we have, and make arrangements to make sure anything that you would bring is going to work. So we're more than happy to accommodate those kind of things. And I would just request that you do those ahead of time. The other thing is I do not like to have the jury just sitting in the jury room waiting while we're arranging for technology and so forth. I like to make as good of use of the jury time as possible. So I would ask that you do those things ahead of time to make sure that everything works.
Very good.
Did you have any other questions on that kind of thing, Mr. Haney, at all?
No, not at all, Your Honor. I appreciate that.
Okay. Mr. Ziegler, anything further from your side?
No, Your Honor.
Okay. All right. Thank you. Mr. Haney, you're free to disconnect. Mr. Isaacson, you're free to go.
Thank you, Your Honor. Have a good day.
Got a little bit. I know it's a bond thing, but can you tell me what we need to do here, Mr. Miles?
Your Honor, my client, Sergeant Major Ogden, has a business where he has developed a product that mimics explosive devices, but they're safe, and it's used in the training by the U.S. military. It's operated here in Kalkaska County. This charge has come along. My client has no prior criminal history whatsoever. There's no indication that alcohol was involved. And because of my client's business, he often has to entertain military personnel, and he has to leave the state from time to time, you know, for sales purposes and meetings with the U.S. military. So we brought a motion asking that he be allowed to be able to drink and that he'd be allowed to be able to leave the state for business purposes. And that's basically it.
Mr. Ziegler.
Your Honor, in terms of Mr. Ogden leaving the state for work purposes, I don't particularly have an issue with that. I have no reason to believe, any particular reason to believe that he's a flight risk. In terms of the bond conditions regarding drug and alcohol testing, those are standard conditions. I don't know if the court has a record of any violations. I'm not aware of any, but it is a serious case. Mr. Ogden is alleged to have shot his neighbor's dog in the head. So I think some drug and alcohol testing, just to make sure that it's not an issue for Mr. Ogden. There's standard bond conditions. I just asked the court continue this time.
Mr. Isles, what is the current testing regime for Mr. Ogden?
Weekly.
Weekly?
Yes.
Okay. All right, so I don't have an objection to modifying the bond to allow Mr. Ogden to travel. In terms of drug or alcohol testing, it appears that it's not part of the factual basis of this charge or what led to the allegations in this case for Mr. Ogden's arrest. It is a pretty standard condition of bond. I'm willing to adjust that to random as opposed to weekly, just because I don't have any information here that indicates that that's an issue for Mr. Ogden. So I would modify the bond to random. I'm not willing to eliminate it as a condition altogether.
Certainly.
So Mr. House, if you would prepare an order reflecting those modifications.
I will, Your Honor. Thank you.
Right, thank you. People versus Kenneth McClintock, case number 255125. Record should reflect Mr. McClintock's present here in the courtroom today. If I can have counsel put your appearances on.
Ryan, we're going to get the people, Your Honor.
Thomas Seeger, and Mr. McClintock.
Mr. Seeger, can you tell me the status of this file today?
Your Honor, at this time, the people have offered Mr. McClintock an opportunity to plead to one count of possession of methamphetamine with no official offender notice. However, additionally, at this time, Your Honor, he is somewhat inclined to proceed to trial. I did hire an investigator to interview a witness. I did talk to that witness at one point in time, but clearly I cannot call myself as a witness at trial. In any event, Your Honor, if the court would give us an additional status conference somewhere in the foreseeable future, I did discuss with the prosecuting attorney the content of the conversation that I had with the witness. I don't know if he finds that entirely persuasive, but it would be a fact consequence that the jury would have to determine or consider. So to that end, Your Honor, if the court gave us an additional 30 to 60 days, that should be a sufficient time. If you wish to set up for a trial somewhere on its calendar, I assume that these things will be remedied within a reasonable period of time and well in advance of trial.
All right, would you, so based on your investigation, you're not in a position to advise Mr. McClintock whether or not he should take the plea at this point, and you'd like to be able to investigate that?
I did discuss with Mr. McClintock my discussions with the prosecuting attorney, and he is not currently inclined to accept the plea. So whether or not he's willing to change his mind after I receive a written something or other or some oral report from the investigator, I guess I can't say. So to a lesser extent, Your Honor, I would say that I'm not in a position to say that I have all the relevant information for which he can make a knowing decision about how he wishes to proceed.
Do you think you'll have that within the next 30 days?
I suspect I'll have it within 30 days, Your Honor. I did reach out to the investigator this morning and did not hear back as to whether or not he's been able to make contact with the potential witness.
Okay. All right, so Mr. Ziegler.
Your Honor, I'm familiar with the witness that Mr. Seeger is describing. I believe it's the co-defendant that was in the vehicle. I don't think the statement's going to be meaningful to me, but Mr. Seeger's client wishes another 30 days. I don't oppose it at this time.
Okay, so I did set today as a plea cutoff. Based on your investigation, Mr. Seeger, I'm willing to extend that an additional 30 days. So Mr. McClintock, when we're here next, you'll need to have a final decision about whether you want to accept any plea offer. Okay. After that next hearing, if you say you want to go to trial, that's what we'll do. All right. So I won't accept any pleas to lesser charges after that next hearing date. Okay. All right. All right. Anything further on this one, Mr. Seeger?
No, sir.
Mr. Ziegler?
No, Your Honor.
Mr. McClintock, did you have any questions at all?
No, sir.
Okay, thank you. Mr. Vogler can come forward, please. People versus Sean Vogler.
Your Honor, he's live, so I'm not sure if they brought him here or if he's in Zoom.
I think we might have him on Zoom here.
Sure.
Hi.